Good morning, everybody, or rather, good afternoon. My name is Chris Justice. I'm an associate with Samfiru Tumarkin. And as always, I'm here to join you all today in hopes of answering as many employment law related questions as possible. So please do get your questions in, whether it has to do with something you're wondering going into a working relationship, maybe something going on during the work itself, or maybe you've lost your job or been let go and you're wondering on your way out what is fair and reasonable, what your options are. So as I say, get your questions in. I'll do my best as I do every week to answer as many as I can. But as many of you know, I also like to start off with a few topics, just some things that are trending in the news lately. And one of the first things I wanted to talk about had to do with Starbucks. So there's been some headlines being made with respect to Starbucks because an employee at Starbucks was fired as a result of apparently not following policies that Starbucks had when it came to those coming into the workplace with an illness or sickness. And there was some understanding from Starbucks that actually this person had symptoms related to COVID-19 and had been coming into work. And when Starbucks found this out, essentially what happened later on is they let that person go. And the controversy or the headlines that were made had to do with the fact that the symptoms that this employee was suffering actually were not related to COVID-19, but rather a very rare form of blood cancer. And the employee had actually communicated as much to their employer, but nonetheless found themselves without a job, having been fired from Starbucks. And so, as I say, Starbucks is coming under some fire for the way in which it handled out this termination. And I thought that this sort of topic brought up a lot of interesting issues surrounding employee disabilities, employee illnesses, and sort of the effect that this can have on the workplace and what somebody's options are when it comes to these sort of things. So as far as an employee being terminated for contracting an illness, that generally is not to happen. And in fact, if an employee does lose their job as a result of an illness, in most cases, there's going to be some strong concerns around discrimination, discrimination around somebody's disability and illness, which could definitely qualify as a disability. And that's a ground that's protected under human rights legislation. So number one, any employee who is suffering from a disability, suffering from an illness, and either, needs accommodation, but are not being given that accommodation, or have found themselves without a job after disclosing the illness or after going through the issues with the employer, definitely give us a call. Got to get some legal advice because, as I say, there not only are going to be some issues resulting in human rights violations, but also you would be looking at your full common law severance entitlements otherwise. So in this particular employee's case at Starbucks, as I say, they lost their job for an apparent failure to follow COVID policies. But in actuality, what will happen is this person will now have the ability to go after Starbucks potentially for their full severance plus additional damages for bad faith on account of having that disability, having that illness, and not essentially being afforded any accommodation and actually being terminated. So that's sort of the one of the main news topics that has been popping up. And as I say, it brings up a lot of questions relating to illnesses, relating to accommodation, and relating to employers just sort of jumping the gun and making a very hasty decision, thinking one thing when they should have made further inquiries at the very least and should have looked to accommodate that employee rather than letting them go. So that was one of the stories I wanted to talk about. I have another story that came up actually. There was a farmer in Saskatchewan who was ordered to pay over $80,000 due to a breach of contract. And after receiving the contract over a text message, the employee, or rather the employer, had responded with a thumbs up emoji. So there was a contract sent to the employee. There was no actual words that were spoken about accepting the contract, but there was a thumbs up emoji. And it brought up the question as far as under what circumstances are contracts made or effective between an employer and employee. Do you need to, as an employee, sign a contract? Do you need to, fill out some sort of paperwork? Or can you exchange an email where you might say something, or you might put an emoji with a thumbs up indicating that you might be agreeable or okay with the contract? Is that sufficient? Does that suffice for purposes of there being an actual contract in place between the employer and employee? And so I think as we get further and further into technology, as more and more people use emails, other forms of technology that might not be your traditional signing of a piece of paper, we've got electronic signatures, and now we've got emojis where people are putting thumbs up. And in terms of the digital age, I think there's a serious concern that these forms of acceptance can actually take effect. Just like I say, a simple thumbs up nowadays may be enough to conclude that there was an agreement reached between both parties, and the employee or the employer may not require that there be an actual contract signed. And of course, if you're an employee and you've been sent a contract, say by email or in any case, you want to be very careful after that point how you communicate your acceptance of that contract and what you communicate to your employer in general. You may not think it, but simply a few words in an email may actually suggest that you've agreed to a contract, and they don't have to necessarily say, I agree to the contract. There could be other things that could be stated in an email or stated on a phone call that may lead one to believe that the contract has been accepted or that you've agreed to the terms of whatever is being put in front of you. So as I say, regardless of what it is, before communicating with your employer, when it comes to being given contracts, or thinking that maybe if I send them this one email, it won't really matter, you want to give it a bit of a second thought. You want to get some legal advice, just because obviously in this Saskatchewan farmer's case, that emoji could have very well been enough to signal that there's an acceptance of the contract. So as time evolves, there may be other forms, other electronic or digital forms that people can essentially agree or signal they've agreed to a contract. And so people just need to be alert to that as we sort of go forward in time. I've got another topic I wanted to touch on, just dealing with many companies and employers having to make adjustments as a result of the pandemic and as a result of how the workplace has changed. So whether you're now working remotely from home, or maybe you're in a hybrid situation, or you're working in the office full time, since the pandemic has started, we've nonetheless seen a lot of changes in the workplace in the terms of how it's set up and how it's structured. And included in these changes have been situations where employers actually increase somebody's workload or decrease somebody's hours, or just make changes to somebody's employment in general. And it all be under the guise of the COVID pandemic, of changes that have resulted as a result of the pandemic. And a lot of people come to me and think that their employer actually has the ability to make big changes to their employment, so long as it's being done in good faith, so long as it's, not something where they're being targeted specifically. But for the most part, if your employer is making significant changes to your employment, regardless of what the context is, if you haven't specifically agreed to those changes or given your consent in some way, your employer is actually generally not allowed or able to make big changes to your employment. And you as an employee would have an ability to basically tell your employer that you do not agree to the changes, and that while you're more than willing to work out what you agreed to work for based on the contract you may have signed, you're not willing to agree to whatever changes are being proposed. And if you give that kind of pushback to your employer, again, assuming it's a significant change, you want to first of all put it in writing, but then that's going to put the ball in the employer's court. The employer is then going to have to decide, even though this person has clearly stated that they're not agreeable to these big changes, are we going to try and force these changes on them? Are we going to tell that employee that if they don't do what's being asked of them, or they don't agree to the changes, they're going to be seen as having quit their job? Because if the employer does that, then they're going to be at risk of having constructively dismissed or terminated that employee. A constructive dismissal is where there's been a significant change to employment that's not been accepted by the employee, but nonetheless where it's been imposed by the employer onto the employee. So that's in law what's known as a constructive dismissal. And so people just need to continue to be aware that they have options in these situations. They don't have to accept changes necessarily if they don't want to. And they also shouldn't be silent about it. A lot of cases I've come across have been involving people who have been told that their employment is changing. They haven't said yes, they haven't said no to it either way. They just keep on working. And then later on down the line, they discover or realize that they're no longer open to doing it, but they were silent for the whole time. They didn't make any fuss, they didn't raise a concern. And so silence can be treated as acceptance. And so if you're in a situation where your employment's being changed quite drastically, just know that the longer you go on having that be the case, the longer you go on being silent and not raising the issue, the more likely you'll be seen as having accepted that change. And if you try and get in touch with a lawyer afterwards, it's going to be a lot harder, if not impossible, for that lawyer to essentially reverse what's been happening. So if you've been presented with changes, regardless of what the context is, before you start getting into any substantial communications with your employer, you're going to want to get legal advice just to make sure that your T's are crossed, your I's are dotted, and that you're not saying anything that could potentially harm you. Just like in the case with the farmer in Saskatchewan also, who just sent an emoji with a thumbs up thinking it wouldn't necessarily harm them. But with that said, I'll get into some questions that you all have today. So thank you as always for those. I've got one in from Laura Lee on YouTube, who's saying that their employer has let them go today, stating that they need someone with more experience in transportation. Laura Lee says that they were very upfront with the employer about their experience when they were hired, and they were given 1 week of pay. And Laura Lee has started in April of 2023 and is asking if they have any recourse in the situation. So I think that if you were very upfront about your experience when you were hired with your employer, and then later on they decided they wanted somebody with more experience, there could be an element of bad faith there, although you would have to figure out, if you could, when they decided the experience was required. It is possible that on one instance they didn't want it, and then for circumstances maybe out of their control, they changed their mind, and that's not necessarily bad faith. But on the other hand, if you're somebody who joined a company and were let go very recently into that job, and you were maybe poached from a job you had before, then the employer that let you go could be in some hot water. A lot of times, far too often, people end up leaving jobs that are very stable, that they've been at for, say, many, many years, to join another job after they were recruited or basically poached from the company. And then they join that company on an understanding with the company, and then they get let go very soon after. And they come to a lawyer like myself and they say, look, Chris, I wouldn't have left my job of 5 or 10 or 15 years had I known I was, going to be set up in this way or let go very early on at this other job. And that's, as I say, where a lot of employers can get into hot water and actually end up paying more to the employee because of the fact that they induced them to leave their previous job on an understanding that they'd be having this, long-standing experience or tenure, only to find themselves without a job, just a month or a few weeks in. So that could be the case in Laura Lee's situation. But in general, if you are somebody who's been let go from your employer, they owe you severance. And even if you're somebody who has a low amount of years of service or months of service with a company and you've lost your job, do not assume that, only 1 week's pay is going to be enough. Don't assume that you're owed very little money. There are a lot of cases where employees have worked for a company for less than a year, and yet they've still ended up receiving 4, 5, 6 months of severance. So in Laura Lee's situation, I'd definitely be contacting a lawyer because of the fact that they were only given 1 week, and also to kind of flesh out maybe some potential bad faith as far as the representations that were made by that employer that's let them go. But thanks, Laura Lee, for your question. I've got another one in from Reggie MacArthur on YouTube, who's saying that their employer has told them because they work in the financial industry, they're not entitled to receive overtime pay, and they're asking whether or not this is accurate. And I'm not aware of a blanket exception or exemption that applies to the financial industry, so I don't think that's actually correct. There are certain occupations that are not entitled to overtime, as I say, in certain situations. But generally speaking, most people are entitled to overtime regardless of what industry they're in. Of course, assuming they work in Ontario anyways, over 44 hours in a given week. So, Reggie, it may be the case based on your specific position within the financial industry that there's some exemption applying to you as far as overtime pay is concerned. But I wouldn't assume that that's the case industry-wide. So this may be a question you want to give us a shout about, and we can try to flesh it out a bit more, especially if you are actually working overtime hours and you're not getting paid. You want to take action on something like that sooner rather than later to, as I say, capture all that accrued overtime pay. I've got another question in from Sandy on YouTube who's asking how to reply to a termination email regarding time to review a just cause severance offer. They were given 4 days, but they need a few weeks in order to potentially proceed further. And that's a good question, Sandy. So anyone who has been let go, if it's for cause, if it's not for cause, you're likely going to be told that they want an answer or response from you very soon. Sometimes it's 4 days, sometimes it's a week, maybe it's a couple weeks. But I think people should understand that when they're being given deadlines on accepting severance offers, generally speaking, those are not hard, fast deadlines. They're being put there because, of course, the company wants you to sign some paperwork so that, you can accept the deal and then they don't have to worry about you coming after them later on. But in most cases, if you're an employee and you ask your employer for some extra time to review and consider the severance offer, that's exactly what I would say. I would send the employer an email. And in the email, I would just simply say that, I've received the offer, that I need some more time to review and consider my options, and that I would appreciate it from the company if I could get an extension or some added time to get back to them. Usually a week or two, there's no problem. Even more than that, for the most part, I've found has not been a problem. Your employer doesn't necessarily want to be seen as putting you under pressure to accept something, because then later on that may come back to bite them in the butt. So I don't think there's any problem in asking for an extension. And if the employer responds by saying, we're not going to give you an extension, we're not going to do that, then I definitely say give us a call, but also try to seek some legal advice as soon as you can as well, so that, things can move along, at a speedy rate. Because if anyone's going to be delaying things, it's usually the employer. But yeah, don't worry so much about deadlines for those watching in general. And if you need time, always ask for it. And I would say only until you get told that there will be no extension or that you need to decide, I'd say definitely get in touch with a lawyer by that point if you haven't already. I've got a question in from Deanna on YouTube who's asking if an employee's on a medical leave of absence with a note that indicates a length of absence being required, can the employer demand a diagnosis and treatment information? So generally speaking, employers cannot demand a diagnosis. They can demand at most a prognosis, which is essentially just confirming how long you'll be absent from work. And they can also ask for an idea of what your limitations or restrictions are. So if you can't lift a certain amount of weight, or you can't sit for a certain amount of time, or you require some form of accommodation that's related to some of those limitations or restrictions, then your employer will have the general right to ask for that information, just because it'll help them in their own duty to accommodate your illness or your disability. But as I say, as far as diagnosis, no. As far as treatment information, generally speaking, you don't even have to provide that either. It's just typically a prognosis, an idea of what accommodations you need, if any, and sort of what that's related to as far as your limitations or restrictions are concerned. A lot of times employers try to get as much information as possible. Sometimes they know they're not entitled to it, and they're just hoping to get as much as possible so they can, do whatever it is they're going to do. But yeah, if you're being pressured by your employer to give more information than just that prognosis and the accommodation related information, that could be an issue, and definitely something that I think would be worthwhile speaking with a lawyer on. Got another question from Deanna as well. With a medical note, is the employer justified in continuously emailing the employee for further medical diagnosis and treatment plans? And in general, that can be a problem too. That's when it becomes borderline harassment, if not harassment, especially if your employer is constantly asking you for things that either it doesn't have the right to ask you about, or asking you for things despite you having given an update recently. So, for example, there are some situations I've come across where an employee will provide a prognosis, or the doctor will provide a prognosis to the company, and the prognosis will say something like, I'm going to follow up with the employee in a few weeks or a month to see where we go from there. And yet the employee is getting sent emails from the employer every 2, 3, 4 days, even though that medical note had just been sent and there's no update on that person's medical status. And as I say, that's when it can become borderline, if not harassment, and employers can then kind of get into a bit of hot water as far as bad faith and all that kind of stuff is concerned. And so if that's the situation you're in as well, you definitely want to get a lawyer involved, just so that they can kind of talk you through the steps and how best to communicate, and also when to stand your ground and basically say to them that they're not entitled to that information. Thank you, though, for your questions, Deanna. I've got another one in from Philip on YouTube, who's asking, what about many employers know the law, so they implement changes in a smaller segment over a year or two? Okay, so I think, Philip, what you're getting at is employers who make changes to your employment, but only do so on a very minor basis and sort of make multiple small changes. So maybe they're trying to avoid being seen as making one big, huge change to your employment. So they kind of chop it up into several different minor changes that happen, Philip, as you say, over a year or two. And I think that, when you look at 1 or 2 or 3 little changes on their own, it's probably not going to be a big deal. But as they add up, I think it's important for employees to be aware of this. And because there definitely could be a point in time where all of those changes, or enough of those changes, do amount to one big change. And so you could have maybe in good faith told your employer that, you'll do this change or you'll do that change. And then they just kind of take it for granted and keep adding changes. And if you start to see that kind of a pattern, I think making a list of the changes and how long they've happened over the course of the year or two is important. It may involve you having to get some legal advice, because you're going to want to figure out, do these all amount to one big change, or does this constitute a constructive dismissal? And so it is possible to make small changes, a number of small changes, and not necessarily be constructive dismissal. But it's also possible for employers to keep adding and adding and adding and adding to the point where after a year, your job is fundamentally different than it was before. So I would say in these situations, you need to just be mindful, make notes, make a record of all the changes, and get in touch with a lawyer before communicating your disagreement or your disapproval of it. Because I think there is generally going to be a way for you to kind of nip that in the bud, but it'll just depend on kind of what those specific changes are and over how long of a period of time they've happened. I've got another question from Deanna about, a third question, saying that their employer threatened her as abandoning her position because the diagnosis and treatment plans have not been willingly disclosed, and Deanna's nonetheless provided valid medical documentation. So unfortunately, a lot of employers do take the position that someone is quitting their position or abandoning their position when they don't give the employer what the employer thinks it's entitled to, or when the employee doesn't do something, maybe perform a certain task that the employer thinks the employee should be doing. And you shouldn't assume that you are abandoning your role or you're quitting it, or this is a reasonable expectation to have. It'll depend on what's reasonable in the circumstances. So as I've said, in general, Deanna, when it comes to diagnoses, that's not something employers are entitled to. When it comes to treatment plans, the information may be relevant as far as treatment plans are concerned, only as far as, again, those potential limitations or restrictions are concerned. So if a treatment plan, for example, requires you to be absent from work 2 days out of the week, that may likely be something that your employer is going to want to know. But if a treatment plan involves giving you certain medications or whatnot, then that's, as an example, information that your employer wouldn't generally be entitled to. I've got a question in from Sandy on YouTube, who's saying that their ex-employer claims not to have kept timesheets, whether overtime or leave requests, saying it's not legally required. But Sandy knows for a fact they have them, and that Sandy's owed overtime, unpaid days, and sick leave. Can they access the file? So there is the potential for you to get a copy of your employee file. You may have to either go through the Ministry of Labor to get that. And I would say, as far as owed overtime, unpaid days, and sick leave are concerned, the ministry could be a potential option. I typically tell people, when it comes to in terms of severance, do not go through the ministry. But if it has to do with unpaid wages, overtime, or sick leave, that could be something on a more cost-effective basis that you could go through the ministry with, and the ministry could do some investigating on its own and actually potentially order the company to release some of the documents. If you don't go through that process, the other general way would potentially be to sue your employer. And in the course of a lawsuit, in the course of litigation, there's going to be a part in the process where both sides have to exchange relevant documentation. And so that could be another point in time where your employer would have to provide documentation as far as it relates to the case. It may depend on exactly how much overtime and unpaid days or sick leave you're owed. That may determine whether it's worth your while to pursue a lawsuit, because lawsuits can be costly and take time as well. But I would say that in general, you do have at least a couple of options. And I would say, at the very least as well, give us a call, set up a consultation, because there could easily be, based on what you're saying, a breach of contract, which, depending on how much we're talking about, could be quite substantial. So give us a call. Happy to set up a consult and kind of talk you through that information. I've got another question in from Bill Zhang on YouTube, who's asking whether or not their employer can disable their work accounts while they're away on a short-term disability leave. And most companies in general probably have a policy that says that if you're on a disability leave, of course, you're not to be working, although it would depend if you're partially disabled and doing a modified work schedule or not. But if you're on a complete disability leave, you're not at work, you're not doing anything, depending on the company's policies, they may be able to disable work emails or access to certain work-related things while you're on the leave and hopefully recovering and getting better. But it also may come down to what your contract says. So you shouldn't automatically assume what your employer is doing is okay. And this just applies in general. If you're somebody that's wondering whether or not your employer can get away with doing certain things to your employment, look at your contract. A lot of times there is some language in a contract that allows a company to do certain things that they may otherwise not have that ability to do. But in general, I think people can look at a contract or their contract as one of the first points of reference in terms of, like I say, it could be anything from disabling work accounts to how much severance they owe you, to whether they can make changes to your employment and what those changes look like. But thanks, Bill, for the question. I'll answer one more question, but that'll be my time for today. So I've got one in from Elijah Cosby, who's asking whether or not management and the HR rule of he said, she said after a complaint of verbal abuse and intimidation, if someone can be forced to go back to work. Okay, so Elijah's asking, can I be forced to go back to work with somebody that was involved in verbal abuse and intimidation without any way to protect myself from this happening again? So I think that if there is evidence of verbal abuse and intimidation or harassment and a complaint has been made, one question would be, what was the outcome of the investigation? You know, your employer is generally required to investigate harassment as part of its obligations under occupational health and safety legislation. So they have to investigate a complaint. They have to generally do a full out investigation. They have to make findings. The investigation has to be done well. It has to be done correctly. There can't be bias, of course. And depending on what the outcome of the investigation is, there should be some resolution as far as what's going to happen to the person who may be found to have committed verbal abuse or intimidation. If there is a finding that somebody was abused or intimidated or harassed, then the employer has to take action. They have to, in some manner, discipline or advise the person who did the abusing or the harassment in terms of what a correct behavior should be. If not, let them go, depending on how severe the case is. But also, I think in terms of going forward, if you're somebody who's been in the workplace and you've been harassed, abused, intimidated, and your company says that they don't believe it happened, or it's a he said, she said, then what the company is basically saying is that they haven't found enough proof to, prove out that verbal abuse or intimidation. But they should still arguably accommodate you in terms of going back to work by not being around that person. So if there's a way for you to, basically avoid dealing with that person, to do your job without having to interact with the person that you were having problems with, the employer should be doing that and making every effort they can to accommodate that situation. If it's just a one-off and somebody was intimidated or verbally abused and that person was reprimanded and they're apologetic and they express remorse, then it may not necessarily be the case that they have to be terminated. The employer may decide to keep that person, but that still doesn't mean, as I said, that there shouldn't be some form of accommodation to hopefully avoid the two of you interacting so that you can do your job or the main facets of your job. And, if they're going to keep this person, this other person can do their job. But to force you to be in a situation where it's uncomfortable or where you've asked specifically for accommodation, that's sometimes where the employer can get into hot water and be seen as, having failed to accommodate the situation or not essentially protecting their employees when it would have been reasonable to do so. So Elijah, if you're in a situation where you're not being afforded that opportunity or that ability to kind of steer clear from them, definitely give us a call. If you're looking to leave the workplace and try to get some severance out of it as well, I think you should give us a call and schedule a consultation so that we can kind of flesh out your situation a bit more and figure out exactly every option that you have, whether it's to go back and be accommodated, leave and potentially get compensated or whatnot. But with that said, as I mentioned, that'll be my time for today. I thank you all again for attending. Definitely get back if you haven't had your questions answered. We do these things all the time. And actually, you can join Jeremy down below there. It says this Thursday, July 13th at 2:00 Eastern for more employment law related Q&A. So tune in then if you've got some questions. But otherwise, and as always, I hope you have a great rest of your day and do take care. Thanks again. Bye for now.